happier.
Yeah. I'm lucky to be on a committee with Terry. So the worst thing ever was when we went virtual.
Yeah.
Virtual.
Didn't deliver, huh?
All right, our next witness, who we are going to take before we have a break, Michael Harrington. Michael is Commissioner of the Department of Labor. Michael, take it away.
So good morning, everyone. For the record, Michael Harrington, Commissioner for the Vermont Department of Labor. Going to talk just a little bit about the bill that's in front of you. And I think Judy did a great job and other witnesses. I think, you know, from the department's perspective, we certainly did not put forth this request and we don't support it. And I can talk a little bit about why. But I think the question that really should be asked is what is the intent of this section of the bill, right? So what problem are we trying to solve with this legislation? I think when it was first being discussed in Senate Economic Development, the question, the perceived problem was, are people being paid correctly under Vermont's prevailing wage law? Or are people being miscoded, misclassified, whatever you want to call it, and being paid a rate that is different than what they should be paid under the prevailing wage law? The department testified during that time that while that does happen, there are already remedies for individuals to take if they are miscoded and paid a different rate. The department operates our wage and hour unit. And so the role of that unit is to receive wage complaints from Vermont workers and then to investigate those complaints and in the end come to some determination as to whether or not the individual should have been paid additional wages. And so again, there is a remedy in place already for situations where someone may have been coded differently, paid a higher wage, and the individual was not paid that amount. I think the areas where we could be just as impactful is public awareness and education and informing companies, construction companies about Vermont's prevailing wage law and what the coding or classification piece is around that law. But I would also say that in many cases, the people who are doing state contracted work for large dollar amounts are very familiar with prevailing wage law. And I would guess in many cases that if there is a discrepancy in how somebody is coded that impacts their wages, the employer is pretty quick to fix it. It's not, I don't see cases where it's done maliciously or an intentional manner to pay somebody less. It may have been simply that they were just accidentally coded at a different occupation than the one they were working under. So again, the concern around this is, and I'll echo what Judy said, it puts an exorbitant amount of work on contractors, large and small. And, we're talking about folks that have 50, 60, 200 workers more, and they're doing weekly payroll certification, having to provide that. It's not necessarily clear, does the payroll go to the organization that they are contracting with, right? So who receives that payroll? How is the payroll transmitted? It's private, protected information in some cases because it includes social security numbers, depending. And then who's reviewing it and what level of understanding do they have around not just prevailing wage, but whether or not an employee was doing work and was coded correctly, right? So it assumes that the person receiving the payroll and reviewing the payroll has intimate knowledge of the work that was being performed and the people who were doing the work. And then I think, the other piece is it creates a whole nother component for state government to have that isn't currently in place. So, There are agencies that do have certified payroll that review that. AOT is one that I think we're all familiar with. But they have a special unit that is in place to receive that payroll and review that payroll in compliance with federal regulations. But the Department of Labor certainly doesn't have that capacity to take a proactive review of weekly payroll from, multiple employers of hundreds of workers. And I doubt that many other agencies do as well. So I think there's the impact it has on small Vermont businesses or large Vermont businesses, the impact it has on state government. And I also don't think that it's actually going to solve the problem, which was the original intent. I'd rather encourage us to focus on, again, education, making sure employers are aware of the requirements, making sure they understand the classification system, and that they're doing their due diligence to ensure their workers are paid the rate they're supposed to be making.
Questions? Yes.
Does anyone else have questions first? Did you testify in the Senate on this bill?
Yes.
Okay,
In Senate Economic.
yeah. Judy had brought up a form. Was that discussed in the Senate? Do you know, like, what?
The one she showed on the screen?
Yeah, so that's for federal funds.
Yeah, it wasn't, I don't believe it was discussed in Senate Economic Development, at least while I was there. And really the department, our role right now with regards to prevailing wage is very small. Our labor information division helps set the Vermont prevailing wage and issues the Vermont prevailing wage report on a regular basis, but we don't certify payroll or prevailing wage, nor do we hold contractors to that payroll unless there is a complaint about somebody not being paid the rate they're supposed to. So really where that comes up is whether it's, AOT or BGS or others.
Okay.
So,
Yeah.
Other questions? My question is, you said you have a wages and hours unit.
Yes.
Do they receive many complaints
They do, hundreds over the
About-
course of a year.
about prevailing wage?
No, I would say most of them are not about prevailing wage. I was just talking with our general counsel who oversees that unit. And they have had a couple that deal with prevailing wage. I'd have to go back and look to get you the number for like 2024 or something like that. But, again, what we have found is that we identify that a miscoding occurs. We calculate what the rate should have been. We look at the hours worked over the course of the year. We find out what the difference, and in those cases, the employer, these are all the ones that are dealing with prevailing wage are upstanding employers in Vermont, trying to do the right thing. They just maybe don't have, maybe it was a mistake, or they don't have the internal controls regarding payroll. So they're pretty quick to make it right. A lot of what comes before the wage and hour unit are, things like side jobs, gig economy jobs, or jobs with maybe non-reputable employers, or plain disputes around hours worked, and pay. So it ranges the whole gamut. I don't see a lot that I'm aware of that deals specifically with prevailing wage.
I just wonder, because I would assume, without knowing, that one concern would be that, in fact, people aren't paid prevailing wage, and they're particularly not paid prevailing wage by small contractors.
Yeah.
And that we don't know that, if that's the case.
Yeah.
I'm
And
not saying it is, I'm just saying that might be a concern, which is why I asked whether your wage and hours unit hears that, and what I'm hearing
I can-
is no.
Yeah, and I can certainly go back and ask them and get some detailed information. The one challenge with just so you know, our wage and hour unit has currently 2 investigators, right, for the entire state. So again, when we talk about things like if we want them to review certified payroll from all, state contractors, they obviously can't do that. And certainly not in a timely manner to get someone timely pay. So I'm happy to go back and look. The challenge, right, is right now it's a complaints-driven system, right? So the employee has to know that they were, cheated out of pay and or not paid the correct amount, and then they would have to file a complaint to do that.
Yes, go ahead, Elizabeth.
Thank you. So just to clarify, what is it per, something per hour, wages per hour? Is that right? No, the department.
Wage and hour unit.
Wage
Or
and
wage-
hour unit. Okay, so the wage and hour unit does collect data on the types of complaints that they get?
They collect data in terms of like who the complainant is. They conduct a full investigation, whether we can query their system for which ones are prevailing wage. It may be a little bit more of a manual process to go through and see which ones were related to construction projects and prevailing wage. We'd have to.
I guess what I am curious about is, it seems like it would be, a checkbox on a form to just add what type of complaint you're receiving. And I'm curious about the percent of misclassification complaints. And also how long from start to finish that type of complaint takes to investigate.
Yeah, I'm not sure. This would be an interesting piece. I'm not sure most employees know what prevailing wage is, or whether or not they understand the calculus behind it, right? So when someone makes a wage complaint, I'm not sure they would even know at that point to say this is a prevailing wage complaint and check that box on the form. But again, we can certainly go through and find out which, again, I don't think it's more than a handful over the course of a year that are related to prevailing wage.
Well, I was actually asking about the misclassification.
Yeah, so I think the piece, and this is more about clarifying your question, so I make sure I answer it correctly. So when we talk about prevailing wage, we're talking about the coding of an individual. So were they coded in the correct occupational class? Uniformly, when we talk about misclassification, we're talking about, was somebody paid as an independent contractor, or were they paid as an employee? That doesn't have any relation necessarily on prevailing wage. So those are two different topics, and happy to talk about misclassification, but typically where we see that is in construction, home building, others where there's a general contractor. But we see it across industries where individuals are treated as subcontractors or an independent contractor when they really should be classified as an employee. And sometimes it's done unintentionally, and the employer doesn't recognize that they're misclassifying somebody or believes they're doing the right thing. But often, obviously, what comes to the Department of Labor is when it's being done intentionally. And that's usually to avoid having to pay either worker comp coverage for those individuals, but more often it's about lowering the unemployment insurance they're paying into the unemployment insurance trust fund, because those are calculated on the number of employees you have. And so it is, it's a common and issue that has been around way before my time here, and continues to be a topic that's discussed about whether somebody is an independent contractor and whether they're an employee, and when it's appropriate to be in one category or the next. So with regards to that, I mean, usually what we find is there's a couple different ways we identify misclassification. We do have folks that conduct audits or reviews both on the workers' comp side and on the UI side, the unemployment insurance side. And that's typically how we'll pick up misclassification. Often what happens is somebody gets laid off from a job, they come and they apply for benefits, and the way our system determines eligibility is based on their work history and the wages they've earned. And so if they apply and they say, I'm an employee of XYZ company, and we pull them up in the system and there's no wages attached to their name or their social security number, it forces us to go to that employer. And sometimes it's a simple system reporting issue, but oftentimes it will lead to some type of audit or review of the company to determine whether the individual is classified correctly or not. I don't know if that answers your question.
Sure.
So, and again, the reason I say that is because the employee-employer question doesn't often play a role in our wage and hour unit. Because again, they're not looking at the relationship between the individual and the employer. They're looking at whether or not somebody was owed wages they didn't get paid. The relationship between employer and the employee typically comes up in unemployment insurance and in workers' comp insurance.
No, go ahead. Just from my experience, on the relationship side and then classification, a lot of times the IRS kind of provides guidance on who should be considered an independent contractor versus an employee. And it's really, anytime I've ever kind of been brought with, we want to hire this person, or this is good, this individual is going to be a contractor, which way should we go? It's an employer should be going to the IRS saying like, or at least looking at their guidance. Is that correct?
You could, but there are very specific Vermont laws
Yeah.
around the test that is used both under workers' comp and unemployment insurance that are beyond the federal law around.
But the guidance is already out there, correct?
The guidance is out there, but there is some federal regulations, and then Vermont goes a step further in how individuals are classified. And usually, again, it's the type of work that somebody is performing, whether they have autonomy over their work, whether they're being directed by the employer or the entity. And so we see that, everything from transportation network companies like Uber and Lyft, or we see that in the film industry where you might hire a cinematographer or photographer or somebody else to come in for a production of a play or a film. And we also see it usually it's small construction is where we see it, where, again, as was mentioned, you might have a general contractor that takes on a small home project and hires somebody to do drywall installation. The question is that person who's doing the drywall doing similar work to what the general contractor can do? How are they being paid? How is their work being directed? Are they a separate company or LLC, or are they being hired as an individual? So that's, again, those are the common places where the misclassification occurs, and both UI and workers' comp have different tests. So they have, for the purposes of UI, there's a very clear, it's called the ABC test. And then workers' comp has a separate test specific to that. In most cases, workers, regardless of whether they're independent contractor or employee, workers' comp insurance is required. But in many cases, whether, the UI contributions and taxes are really based on the employee number and count within an organization.
Saudia?
Thank you. So Margaret, back to the previous statement where you had ended on talking about wages and earnings and pay and compensation. And I just wanted to be talking a lot about construction contracts. And I just wanted to get back into a little bit of the actual compensation and things like that. We hear a lot of testimony on folks who don't get breaks and things like that. And I just was curious, where would one go to find information on that? Who's held accountable and how? Because the amount of testimony we're hearing in different fields of employment of folks who are working and not getting breaks in extreme work conditions is troubling.
Yeah.
And so when we're talking about these things and for folks to be able to be compensated, and how does one navigate that in relation to, because if we're saying, well, we can't really track these things, and I know that's maybe a different field, but for me, I'm just hearing wages lost, compensation, time, tracking, and breaks, there's a thing there. So I'm just, if this is not a conversation for now, right?
Yeah.
That's a big conversation.
Yeah, it's a big conversation,
And
but
so-
I can answer the basic question.
Thank you.
Yeah,
That's where I was going.
so it is a big murky puddle of water, in the sense that most of what you're talking about falls under the Fair Labor Standards Act, which is a federal act. Most of the provisions of that federal act are overseen by the Vermont Attorney General's office. But the big thing is being able to determine what is good business practice, right? So it's a good business practice to give your employees breaks versus what's an employer required to do. And so, an employer may not be required, depending on whether or not it's part of a contract or a collective bargaining agreement, but they may not be required to provide breaks. And so I think one is knowing what's the best practice and what's good business and what is actually required under the law. The third component of that, which I think you talk about in terms of extreme work conditions, is that workers are protected under both federal OSHA law, occupational safety and health law, as well as Vermont's occupational safety and health administration. And so they do have a duty under that law to ensure a safe workplace for their employees. So again, those are the areas where it comes into play. So if they are performing a job in extreme heat or other extreme conditions, they may have a duty to provide frequent breaks, cool off stations, water, hydration, all of those things as a way to protect the employee. So it really, some of that falls under fair labor standards. Some of it would fall under workplace safety, depending on the circumstance. Yes.
Yes.
I would just like to piggyback to what Representative Lamont brought up, and this can be for another time, but as you know, probation officers, correctional officers in our facilities are not given bathroom breaks, are working 16 hours. And this has been going on for quite a long time. DCF workers are meeting juveniles in parking lots, police stations, things like that. These are not safe working conditions. And I would like to know what is being done about those particular places.
Yeah, so one, I won't speak on behalf of the Department of Corrections. I'm assuming you've spoken to Commissioner Demmel about those situations. If you haven't, I would encourage you to have him come in and talk about those instances. I think it's important to make sure we've got a full understanding of the situation and the story. There are avenues, whether it's part of the union and the state's agreement, or it's through the Department of Labor as an intermediary, or whether it's with the Attorney General's office if workers feel like they're being put in an unsafe condition. I think there's a question about what is perceived as an unsafe working condition versus what actually falls under the law as an unsafe working condition. So again, I'm not projecting one way or the other. I just don't know the situation. That's often what comes up, is that somebody's perception of what is safe and unsafe doesn't necessarily squarely fit under a provision of the law. And so I think those are the situations, again, where I don't know how long we're talking about in terms of bathroom breaks or not bathroom breaks, lunch breaks, those types of things, the extra hours you talk about, or where people are meeting clients. Again, some of those may squarely fit under occupational safety and health, or they sound like probably also a gray area that would take some conversation and some review. But I would encourage you to talk to Commissioner Demmel if you haven't.
Thank you.
I mention this only because I have personally spoken with correctional officers
Yeah.
and their situation.
Yes.
So, thank you.
Yes.
Thank you, Commissioner. And speaking of good working conditions, I would like to give the committee. I want to ask a question before we go, not of you. Next, we have listed Dirk Anderson. Is Dirk?
He is not here today.
Page, you will see that he has been.
He's been removed. Hold on, I will reload my page.
Wanda, Emily.
I just want to go through, got it. Wanda, are you okay schedule wise if we take a 10-minute break?
Yes,
And Emily?
Emily is my deputy and she will not be joining us.
Okay. And David, I know you're here. I think we will take a break and come back at 11. And we'll take our time. And David, are you available if we have to push it to the afternoon after the floor? Because I don't want to rush your testimony like anybody's going to get to lunch. Right? All right. So, yes, Joe.
Godspeed in your next endeavors.
Oh, thank you. I appreciate it. Yep, it's been a wild ride, but it's been a good one.
Oh, that's right. You're taking off.
It's been my pleasure to serve the state